I'm in my office for 4 more days. It's being decommissioned.
Oh, is it really?
Yeah. I'm never here. So
Yeah.
on the road or working from home. So
I think you'll be glad you decommissioned it.
I think so too. It's a nice office, but it's kind of lonely.
Yeah. Not a good time to be in commercial real estate.
Yeah, true enough. True enough.
Who could have predicted it? Like, 5 years ago,
Oh my
3 years
gosh.
ago.
Oh yeah, I mean they're building like crazy.
Yeah.
Mhm.
Good afternoon. Thank you for joining us on our October 25th work session. Up first today, we have Comcast Cable Franchise Agreement.
Mayor, I'll start this off. There we go. About 9 months ago, the mayor and I were approached by Comcast about the desire to implement cable and other type of communications into the corporate boundary of Hagerstown. By that interest, for them to be able to provide the service, they would have to enter into a cable franchise agreement. With that being the case, we went out and got our communications consultants, Bob Dushin and Tom Robinson, and they have been negotiating with Comcast for the past 6-7 months, and have reached an agreement with Comcast that would allow them to offer cable television services within the corporate boundaries of Hagerstown. Bob and Tom and Dave Nielsen are on Zoom with us, and what I will ask them to do is take a few minutes and just go through the highlights of the cable franchise agreement. That would also include the side letter that is accompanying the agreement. So, Bob, Tom, go ahead.
Okay, I'll go ahead and start off. So, as Scott said, it was a intensive back and forth process. We started with the Antietam agreement as a base document because it was substantially negotiated back in the 2013-14 timeframe and had a number of beneficial provisions for the city, and provided constructs around everything that goes with a cable franchise, from right-of-way use requirements to customer service standards, those kind of things. So we met with Comcast negotiators and began the process. They wanted a number of different types of provisions. Our aim all along was to ensure that we developed an agreement that would enable Comcast, being the new entrant in this case, even though they're, substantially giant cable company, that would allow them in to provide service, but also establish fairness and competitive equity between them and Antietam, because Antietam is the longtime provider of cable service to residents and businesses in the city of Hagerstown. So that was really our focus. There was a lot of negotiations back and forth, and we ended up with an agreement that we think is fair and provides that competitive equity that we were talking about, enables Comcast to come in and provide service, enables Antietam to continue to, compete and provide all the services they've been providing for years. So I'll turn it over to Bob. There's about 14 items that are key provisions in the document, and let him describe those to you, and then we can go through any part of the document that you'd like. It's pretty extensive, and talk about it in more detail, answer all of your questions, and make sure that the council is comfortable with how we're proceeding, on behalf of the city and its residents. So go ahead, Bob.
Tom, thank you, Scott, Mayor, members of council. As Tom and Scott have indicated, this franchise has been the subject of intense negotiations between the parties. Under federal law, a city cannot unreasonably refuse to award an additional competitive franchise. So in other words, you just can't say to Comcast, we don't want you here. It's important, though, that the two franchises, the new Comcast franchise and the Antietam franchise, taken as a whole, one is no more favorable or less burdensome than the other. That's what Tom is referring to in terms of competitive equity. Some of the highlights of the franchise include this is a non-exclusive franchise pursuant to federal law. Another wireline video provider could come to the city if they so chose. The term of the franchise is 5 years, plus there's an opportunity for it to go an additional 5 years if neither party objects. Franchise fees will be based on 5% of cable service gross revenues. Under federal law, you cannot get 5% of internet or telephone service revenues under a cable franchise. We have made the cable service definition very broad to maximize the revenues for the city. Comcast is going to provide a $50,000 letter of credit. If they sell the system, that goes up to $100,000. The reason their letter of credit is more stringent or a bigger amount, a larger amount than Antietam's, is because they're going to start from scratch and build a brand new cable system in your city. Customer service standards are included. There'll be 2 access channels. They'll be available both in SD and high definition. And again, I'm summarizing the 14 points. In terms of what Comcast is obligated to build, we have a staggered build-out program in this franchise. Under federal law, you cannot say that to the new entrant, you've got to build the entire city. This is staggered such that Comcast will build a certain percentage of the city. If they then reach a certain percentage penetration rate, then they'll build the next portion of the city. And in a third phase, they'll build out to what equates to 85% of the city if the franchise goes for at least 8 years. We do feel that this is a strong competitive franchise. We have not yet heard back from Antietam. We're certainly willing to listen to Antietam. If there's something in this franchise that they don't feel is equitable, we want to talk to them about that. And the other thing is Scott mentioned the letter agreement. Your code provides that a new entrant for a cable franchise needs to pay a $25,000 application fee. Comcast knows that, and that's going to be due and payable before first reading. Consultants' fees that are above that amount, Comcast is also going to pay to the city, subject to the caveat that they can offset their future franchise fees to the city by the amount of those additional consultants' fees. We spent a lot of time on that with Comcast. I will share with you that they were not eager to pay the application fee or the consultants' fees. They tried to avail themselves of certain things they believe are to their advantage under federal law. We have a different reading of federal law. So this is a compromise. But I did want to make you aware of that as well in terms of their obligation to pay the city. We're here to answer any questions you have. Dick is here to answer any technical questions you may have. And with that, Scott, I'll turn it back over to you.
Thanks, Bob. And I'm sorry, I was calling Dick Dave. I'm sorry
That's
about
okay.
that. The way the process would work now would be next week, we'll have a public hearing at 5:30. That would be followed by a special session to introduce the ordinance to accept the agreement. And then at the regular session at the end of November, you all would vote to officially recognize the ordinance. And any questions y'all might have for Bob, Tom, and Dick. Also, the cable franchise is part of the public record, is part of the agenda. So anybody that wants to take some time and have a good read, it is in their form.
I don't have any questions, do you guys? Good. All right. Thank you.
Hey, thank you, guys.
You're welcome.
Okay, welcome. Have a
See
good
you
evening.
next week.
Thank you. All right, up next we have rental licensing amendment with Kathy and Paul. Hi, good evening.
So we have some technical updates that we need to do here to the rental facilities ordinance. One is, adding and clarifying some items in the ordinance through some definitions, which also includes like adding dormitory and part of the rental unit definition. It's something that we added into the program, but we didn't have that particular line item listed out into the rental unit definition. And some other added definitions of such as the property maintenance code and accessory use of city services, things along those lines are being added in. Also add an exemption for the Maryland, or the land installment contracts per Maryland real estate article. So it's adding that in. That's an exemption to the rental licensing program. It's something that we've been practicing, but it's not something actually in our ordinance. So it's putting that in there so we can actually exempt those people that actually do the land installment contracts per the Maryland real estate article. Also, it's adding a section in there where the landlord and tenants have the right to refuse entry or consent for inspection. So that it gives the landlord and the tenant a right to refuse consent for an inspection. It also adds a section in there where the city, if we identify unreported tenant turnover, that we have to schedule the inspection within a set time frame for those types of inspections. It's been identified by the city as not reported to us. And then lastly, adding a area where if we are denied entry into a unit to do an inspection, the city can seek an administrative search warrant. We had originally talked about this in 2018, but at that time we didn't add it into the ordinance because we were feeling we could use it through the property maintenance code. But working with the attorneys, we feel it's best that it's being added into the rental ordinance. And this includes, like for refusal, includes like the passage of time since the last inspection, the nature of the premise, meaning like are there code violations that we can observe, and also the conditions of the neighborhood. Just for knowledge. Well, that is where, that has been in since the 1967 Supreme Court case for Camara versus San Francisco. That's just the 3 standards that they put in that Supreme Court ruling back then, and that's been the standard for code enforcement since then. That's what the attorneys have put together in the document there.
So let's just say that I have a rental unit that has been impeccable all the time when it, I've adhered to all of the requirements of the rental inspection policy, and because of the condition of the neighborhood, and you guys wanted to come in and inspect my property, even though I've never had any violations or anything. And if I said, why should I get an inspection? I just had one, 3 years ago, 2 years ago, whatever. And you say, well, because of the condition of the neighborhood, if you don't let us in, we can get an administrative warrant. I don't understand the condition of the neighborhood part, is what I don't understand. Which gives you, which doesn't have anything to do with a piece of property in that neighborhood.
Yeah, I can say that that's just part of the Supreme Court ruling, that those were the 3 items they said you can obtain an administrative search warrant for. The practices by our office would be that it's the properties that are not in compliance with the program, that's where we would be seeking a warrant for those that are not in compliance after requesting an inspection. So if someone was in compliance with the program, I don't foresee us looking for a warrant to get inside of that unit.
But you could.
In theory, yes.
Right. Yeah. So I'm okay with everything else with that. I'm just not okay with that part. I just, for me, it doesn't make sense that, you could subject me to an administrative warrant even though I haven't done anything wrong.
I can just say that that's been the standard since
I know you
1967
keep
with
saying
Supreme
that,
Court.
Paul, but it doesn't matter. I mean,
That's what
it wasn't in our policy before, and then now we're gonna add the administrative warrant part in, so I'm gonna say that, if that remains in there, because I can't wrap my head around it myself, I'll vote no, but, just because of that
Okay.
one line, so. I mean, I understand the rest of it, I do, I don't understand that.
While I think that component is obviously vague, and could be in that process construed as being an arbitrary or capricious reason for doing so, I think it's difficult to separate it from a specific court ruling in which we're attempting to, you know, consistently abide by for what we're attempting to implement. If you were able to say to me, yeah, you know, we made these things up because we thought these were the you know, the various merits we needed, and, you know, we could pick and choose like a cafeteria menu, but the court determination of the highest court in the land has said, here is your menu, and that's the menu you will operate from. You cannot, you know, split, you know, the items, so to speak, and choose as you will. So for me, I don't have an issue with it, simply because I have an expectation you will use those items in a manner that is applicable to the instance in which is necessary to do so.
Or we could just leave the administrative warrant part out, but still. And that way there'd be no question about whether something's capricious or not.
Yeah, I'm not okay with that.
That's the only thing I have.
Okay. Do you guys have any questions?
Were you done?
Oh, okay.
There are other changes.
No.
All right. Is that, you guys good?
Yeah.
Okay.
But that's okay.
All right, thank you.
All right.
And it's on the 7 o'clock agenda for a vote on introducing the ordinance.
Okay. Thank you.
Tonight?
Thank you.
All right, so we are adjourned until 7. See you back for a regular session.
You know, we could have had this meeting